In this video, I'd like to go over 4 minor pretrial motions. We've previously discussed the 3 major suppression motions, and we've also previously discussed the 3 major motions that anyone in a felony criminal case is entitled to. But in this one, I want to talk about 4 other, I call them minor motions. They're really not minor. They are significant. They are common, but they're just not something that you see in every case. The first one is a motion in limine, and we've referenced it earlier, but you're not going to really see a motion in limine until a case starts to get close to the stages of trial where you think it's going to go. And a motion in limine is an attempt to exclude evidence from trial on a non-constitutional basis. So you're not suppressing it because there's a violation of your 4th, 5th, or 6th Amendment right. There's some other evidentiary reason, whether it's irrelevant, too prejudicial, it's hearsay, unauthenticated. There's some other evidentiary reason you want to exclude it. Again, you can raise these same objections at trial, but the jury's going to see you make the objections, see you try to present that evidence from coming in for their consideration. And you also may put a judge on the spot and have an adverse ruling. So I tend to get that out in advance, and it also shapes the terrain of the trial so I know what to expect. The next common motion, but you don't see it in every case, is a competency motion. In a very derogatory sense, people call them sanity proceedings, but that's kind of not politically correct nowadays, so we call them competency motions, or in some jurisdictions they're called a Bennett hearing. That's just state of Louisiana versus Bennett. It was the case that came up with this. But basically, you cannot prosecute somebody if in their current mental condition they are unable to assist their defense attorney, or they do not understand what is going on. And so it's their ability to understand the nature of the proceedings and assist in their defense. And if you think that there's an issue, a court can appoint independent forensic examiners to make that determination. If they're found to be incompetent, nothing goes on with the case until their competency is restored. Once their competency is restored, the case can proceed. In the event that they are incompetent for longer than the statutory maximum, then it converts into a civil, what's called a Lockhart proceeding, to determine if they need to be civilly committed or if they can be released. The next motion is generally something that's filed by the district attorney's office. It's what's called a 404B motion, or other crimes evidence. As a general rule, someone is on trial for the crime they committed. They're not on trial because of their past. And it's because if the jury thinks that you are a criminal by nature, then they may infer that you did this particular crime, and the courts are reluctant to have that happen. And so as a general rule, you can't get into someone's dirt. But the law does allow for certain exceptions to that. Generally what you see is for like signature crimes. You know, hey, look, I know that you did this crime here because I have evidence that you did very similar on these prior days. So you'll see that in some robberies and some murder cases, some rape cases. What you also see in drug cases is the fact prior drug arrests will come into play in order to show that, hey, they had knowledge that this substance was drugs, or this was no accident or mistake, because you've been arrested 3 or 4 times. How many people are accidentally arrested for cocaine 3 times? That's the general gist of the argument. So those are called other crimes evidence. The defendant's entitled to know about it and is entitled to a hearing on it, and the state does have a burden of persuasion to meet to show that it's a legitimate exception and that you are the person responsible for that prior act. But if admitted, then it's allowed into evidence, again, not to show that you're guilty here, but for some other purpose, whether it's the same MO, it's to show identity, or it's to show lack of a mistake. Those are the common examples. And the 4th motion I want to talk about is very similar to the other crimes evidence, but it's really reserved for juvenile sex crimes. It's called a 412.2 motion, or what's called a lustful disposition motion. And it's pretty broad with a very low threshold. Basically, it allows a prosecutor to present evidence that a person has a lustful disposition towards minors in certain sex crimes cases. And so what does that mean? Well, obviously prior arrest, but even, you know, pornography on your computer, pornography magazines, you know, arguably, you know, a stack of Playboys under somebody's bed could be used as lustful disposition. So it is a general character attack on somebody, and you're not entitled to a hearing, just entitled to notice Now, you may be able to show that it's still irrelevant or some other reasons to exclude it, but you're not entitled to that hearing. And so it's a lot easier of a gate to get through than the other crimes evidence under 404B. So those are 4 other, what I call minor motions. They're common, but not every day and not in every case, and they certainly do not, with the exception of competency, come into play unless there's going to be a trial. If you have any questions, my name is Andre Belanger. You can email me at the link below, or you can call me at 225-927-1234. Thank you.